Right, hello everyone. My name is Kirsten Thompson, and I am the practice group leader for our privacy and cybersecurity group. So today we are going to be talking about privacy and cybersecurity. My practice is both advisory and advocacy, which is a fancy way of saying I tell you what to do and I argue with people. I'm joined here today by Jaime Cardy.
Hi, I'm Jaime Cardy. I'm a senior associate in our privacy and cybersecurity group. I'm based out of Toronto, just like Kirsten, and my practice is primarily advisory and transactional, focusing on privacy, freedom of information, cybersecurity, and a growing amount of AI, risk management, and data governance related work.
So we're going to talk about a specific type of information today, and that what makes personal information special is that it is regulated information. In other words, you can't just do stuff with it. And in the AI economy, data is the thing that feeds the machine. So data, and particularly personal information, is very important. So Jaime is going to start by just giving you a quick overview of this weird regulatory regime that regulates certain types of information. Then we're going to focus on some of the gotchas. And these are things that crop up over and over again in our practice. This is what people fight about, this is where companies go badly wrong, and this is where regulators are interested. So we've got a bunch of those. And then we're going to talk about privacy impact assessments, which is a quick and easy way to solve some of these problems, or at least mitigate the risks of those problems.
Okay, so we'll start by orienting everyone in our privacy laws, and that's because I understand, I'm a privacy practitioner, but many of you probably don't have much clue about what's going on when we speak specifically about privacy laws. In Canada, we have a patchwork of privacy laws. We have our federal laws, our public sector laws, private sector laws, and then also health sector laws. Similarly in the States, and actually to a much worse extent, they also have a patchwork of sectoral laws and then comprehensive privacy laws. I'm really going to root my discussion here in the Canadian privacy law landscape, but I will at times contrast with what we see south of the border. So PIPEDA, or PIPEDA, is our federal private sector privacy law, and it sets out the rules for the collection, use, and disclosure of personal information in the course of commercial activities. So it specifically regulates when businesses, for example, are using personal information during their commercial activities. Bear with me here, this gets a little convoluted, but PIPEDA applies across Canada, except for in the provinces that have enacted their substantially similar legislation. So those are Alberta, BC, and Quebec. And even then, PIPEDA will apply to federally regulated organizations within those provinces. So things like banking, or telecommunications, transportation, et cetera. PIPEDA will also apply to any personal information that's crossing international, so Canadian international, or interprovincial borders, regardless of where that organization is actually based. So for attendees here from outside of Canada, it's important to note the extraterritorial application of PIPEDA and its substantially similar provincial legislation in Alberta, BC, and Quebec. Our federal and provincial privacy regulators are pretty quick to go after global companies that are processing Canadians' personal information, even if they don't have like a bricks and mortar footprint within Canada. It's just as long as you're processing Canadians' personal information, those regulators may seek to hold you to account. Now, separately from those private sector laws, we also have public sector laws. And these address the collection, use, and disclosure of personal information by federal, provincial, and often municipal public institutions. And then separately from all those, we have our health sector privacy laws, which govern the processing of personal health information in the context of receiving health care. So, as I'm sure you can imagine, it's important to orient yourself within these laws when you're undertaking any initiative that involves personal information. So, understanding which single law or which multiple laws may apply to that given initiative. Now, what's key here, and this contrasts to what Bob was talking about with respect to the copyright issues earlier, is that these privacy laws only govern the processing of personal information. They do not apply to other types of information. So sensitive business information is not captured by our privacy laws or any of the obligations they're under. Parameters around the collection, use, and disclosure of those other types of information will typically be addressed through contracts. So with that in mind, let's explore what personal information is. Up here on the slide, we've got the definition of personal information from PIPEDA. And again, that's the federal private sector law. Similar definitions are reflected in the provincial private sector laws. Our public sector and health sector laws are a little bit more prescribed in how the term is defined, but at the end of the day, at their core, what these laws are governing is information that's about an identifiable individual. So the use of the word about here is broad. It applies to information that relates to or concerns an individual. And the threshold for what's identifiable in this context means that there's a serious possibility of identification occurring based on the information either alone or together with other available information. So as you can imagine, this term is interpreted and applied quite broadly in the Canadian context. It includes information that can identify someone directly, such as their name or their email address. But it also applies to information that can identify someone indirectly, such as a person's age or their ethnicity, maybe their IP address or their transaction history. In contrast, those of you who are familiar with the concept of personally identifiable information, which is what we typically see in the States, will note that our personal information is much broader than PII in the US. PII is fairly prescriptive and narrowly defined, really focusing on whether the data can identify a person. Whereas in Canada, more sort of like amorphous things like opinions or inferences about somebody may fall within our privacy laws. So that's personal information. That's the information that is governed by our laws. Moving on to point out one more sort of like unique Canadian concept in our privacy laws is the legal basis for processing personal information here is premised on consent. Typically, organizations are not able to collect, use, or disclose personal information unless they have an individual's consent to do so. You may have caught that I said typically. There are some enumerated exemptions to the consent requirement in all of our privacy laws, but they're drafted narrowly and they're interpreted narrowly. One of those is actually where information is publicly available, which Kirsten will speak to in a little bit. And that's a really tricky concept now because the tides are sort of shifting on what is considered publicly available or what fits within that exemption. And it's important to point this consent piece out because it really is unique to the Canadian context to rely so heavily on having individuals consent. For those of you that are familiar with the GDPR in Europe, it contemplates many different legal bases upon which organizations can process personal data. So consent is one of them, but others include where an organization has a legal obligation or a legitimate interest in that processing. And then contrasting it, the concept of consent with what we see in California's Consumer Protection Act. That act doesn't contemplate user consent at all. Instead, that really focuses on providing notice to individuals about how their information is being processed and empowering them with certain rights that they can exercise over that processing. So back to our Canadian concept of consent. Consent can be expressed, so given verbally or in writing through an affirmative action, or it can be implied based on reasonable inferences from a person's actions or the context. And in order to obtain consent, the organizations need to provide notice to individuals about how their personal information is going to be handled. So that includes identifying what personal information is being collected, the purposes for which it's going to be collected, used, and disclosed, and even identifying the third parties to whom that information may be shared. With respect to the use of artificial intelligence in processing personal information, most of our privacy laws don't specifically address this, and in fairness, most of our privacy laws are decades old at this point, and the relevance of AI to personal information processing is like pretty new. That said, as Chantal alluded to earlier, Quebec, their private sector privacy law has been recently amended, and so it's our most modern one in Canada right now, and it does provide for, or requires notice to be provided to individuals when automated processing is used to render decisions about them. So that's the most explicit statutory requirement that we have when it comes to providing notice about AI processing of personal information. But while it's not enumerated in our other laws, our regulators would expect that level of transparency from organizations pretty much across Canada, even if you're not strictly subject to Quebec's Act. And one last point on consent, which raises some tricky issues with respect to AI, is where processing is based on an individual's consent, the individual has the right to withdraw that consent. And this raises unique challenges in the context of AI. Just for example, if personal information is used in a training data set, such that it's really like baked into how an AI model is operating, and a person subsequently says, you know what, I'm not comfortable with this, like I don't want you processing my personal information anymore, how is that, is the AI model's continued process, like continued operation considered a use of their personal information because that's baked into how it was trained? These are issues that we don't yet have answers to, but we'll see. Before we get to some of the gotchas that we see coming up in our practice, I wanted to highlight a few preliminary privacy issues that need to be considered and addressed whenever we're talking about developing or deploying artificial intelligence. So the first is to get really clear on the roles and responsibilities here. Under our privacy laws, there are typically two distinct roles. There's the accountable organization, also called a data controller in the GDPR context. And then there's the service providers, which are also referred to as the data processors in the GDPR context. The accountable organization is the one that is ultimately responsible for processing personal information in accordance with our privacy laws. They will be the one that typically obtains consent from individuals, and they will be the party that's determining the purposes and the means for which personal information is being processed. The service provider, or data processor, is limited to processing personal information for purposes that are done on behalf of the accountable organization. So our privacy laws will apply to the accountable organization, and that organization will pass down through contracts with their service providers any obligations that they need to basically meet to ensure the accountable organization remains compliant with their statutory duties and obligations. The next privacy consideration that we need to make sure we cross off is where and how personal information is being used in a given model. So I mentioned training data. Is it included in the data that's being used to train an AI model from the outset? Is it being used in data inputs, for example, if you're using generative AI? Or is it being produced by a generative or by an AI model as an output? That too would constitute a collection or use of personal information. So really getting a whole picture of where personal information is involved in your AI processing. And then making sure that any of those processes are compliant with our laws. And if you have any doubts, then maybe you shouldn't be using that personal information in that AI model to begin with. An alternative, however, could be first anonymizing personal information before using it in the model. And I'll come back to anonymization in a little bit. And the third privacy consideration to consider at the output are the security standards that are being applied to any AI in order to protect the personal information that's being processed. So that can include administrative safeguards, like contractual obligations with your AI vendors. It could also include physical and technical safeguards, such as encryption and segregation of your organization's data from any other data that AI model processes. And finally, why do we spend time talking about privacy when we're dealing with AI? And it's because this is really one of those areas where we have legislation that is imposing obligations on AI developers and deployers, and there are real consequences for getting this wrong. So there's a potential for reputational harm, but also increasingly financial risk for organizations that are processing personal information in a way that's offside our laws. I've mentioned Quebec's Act being the most recently amended, and you'll note here on the slide, their privacy regulator now has the power to administer or levy administrative monetary penalties against organizations to promote compliance with that act. And those penalties can be up to $2 million, or 10% of an organization's global turnover for the preceding year. So it's no small slap on the wrist. It's really something that needs to be considered from the outset, just to make sure we're doing this right. So with that, over to Kirsten.
Now that Jaime has scared you with some really big numbers, so far the big numbers only attach in Quebec, but it would be inadvisable to think that the rest of Canada is not following that direction. Most of the Canadian privacy laws are up for review. All of the recommendations include whacking great fines and penalties. So ignore them at your peril. If you are instituting or adopting technologies now is the time to incorporate these privacy safeguards, because undoing it once you've built it, as anyone who's been involved in any sort of rollout or migration knows what a headache that can be. So on to the gotchas. We're going to focus on the collection piece because, as I mentioned, in order to run the machine or run the AI or train the models, you need a whole bunch of information. So which means you've got to get your hands on that information somewhere. So you've got to collect it. And as Jaime has mentioned, one of the ways you can lawfully collect information is using consent. So the takeaway here is you can't just use personal information because you have it. So just because you've got it sitting in a bucket somewhere doesn't mean you can then deploy it for a new thing. So let's use a typical example that comes up. We're going to use the recruiting and application screening process. So imagine you have a company. They're getting really tired of screening candidates. They're going to outsource this to a service provider. In this case, the service provider is Recruiter. And they've got this wonderful whiz-bang AI model that will screen applications. Of course, they have to enter into a contract. They sit down. There's a contract term in there. And it says, Recruiter will use the applicant data to provide the services. Well, duh, of course they are. Train Recruiter's AI and for product improvement. So this is a pretty standard term in most contracts, and particularly you see it quite frequently in US-based contracts. So they both agree, big company or big job code shakes hands, signs a contract, Recruiter builds the portal, they're all good. Now, they launch, and the company's portal now includes a click box. Company knows you have to have consent, so they create a click box for applicants, and that application click box says, by submitting my application, I agree that Big Job Co. will collect and use my personal information for evaluating my suitability for the roles that I apply for. Wonderful, there's your consent. So everything launches, things are going tickety-boo. 8 months later, Big Job Co. gets sued in a privacy class action. Something badly went off the rails here. What was it? So the privacy class action will probably plead unauthorized collection, use, and disclosure of personal information. It'll probably plead negligence, breach of contract, a whole bunch of other things plaintiff's counsel makes up. What happened here is that there's a misalignment between what Recruiter can do with the information and what the applicant was told on the portal. And so this is that controller-processor distinction. So if what the contract clause had said, Recruiter will use the applicant data to provide the services, that would align with what the applicant was clicking on. They understood that that's what's going to happen. What wasn't disclosed was this other thing. So as long as Recruiter stayed processing information for the purposes of providing the services, it was squarely in that processor or service provider box. 100% okay. Starting to get outside that box when it says it's going to train its own AI for these things. Now they're not necessarily in that service provider box. They're making an independent use of it. So now they're starting to look a little more like a controller. And then when they say, well, we're going to also use it to improve our products, well, that's not benefiting Big Job Co. here. That is squarely an independent use. Where Recruiter steps out of that service provider box and makes an independent use of the personal information, it's now suddenly transformed into a controller, and it has the obligations. And any information that the company is transferring or sending over to the Recruiter that it's using that way is a disclosure. So now poor company that thought it was doing everything right has actually made an unauthorized disclosure. Now, if I were plaintiff's counsel, I'd also be suing Recruiter for unauthorized collection and unauthorized use. But this highlights that example of understanding clearly what you're doing with the information and where you fit in that box. Are you a controller, a processor, a service provider, an accountable organization? I gotta say, this is the #1 fight. I can spend a month and a half negotiating an agreement, and I will tell you 2 days will be on the substantive clauses, and the rest of it will all be spent on who owns the data, and who can use it, and how can they use it, and what are the clauses. So this is a big gotcha. And it might be just fine as long as there's no regulatory scrutiny, but I tell you, once something goes off the rails or there's any question about this, this is where the fights are. It's better to be very crystal clear about it up front. And there's ways to solve for this. It might be, in this case, that Recruiter agrees to train its systems only on Big Job Co's data and not aggregate data from all the companies it does business with. There are ways to address this, but you can't address them if you're not asking those questions. All right, the next gotcha. Data scraping. This one is in the news. This is a hot topic. So just like you can't use information that you have lying around in buckets, you also can't just go out onto the internet and grab information to use. Despite what you might think intuitively, just because it's hanging out there on the internet, you can't just grab it and use it. So data scraping is where a company uses a type of software, typically a bot, to run around the internet and scoop up data that's on websites. That data doesn't necessarily have to be personal information, but it can be. It can be things like images of people on social media. It can be your LinkedIn profile. It can be your picture on LinkedIn. It can be my picture on the Dentons website. So all this gets hoovered up, and it's used to train AI. Now, intuitively, you'd think, well, it's out there, it should be free for everyone to use. And this is where that exception to consent comes in. Privacy laws in Canada generally have an exception. You don't need consent if it's publicly available. And this is where the gotcha is. You and I think publicly available means something very different than what the regulators think. So you'll see, I'm going to use the Alberta legislation, just because the next slide will explain why we're using the Alberta legislation. Publicly available information. No consent's needed if it's publicly available as prescribed by the regulations. This is legal stuff. So now you have to turn to the regulations to find out what the regulations say. And this is very clearly where a lot of US folks differ from the Canadian folks. So if you are having a conversation with US counterparts or your colleagues or your US counsel, you will find you're talking at cross purposes because this comes as a surprise to them. So now you've turned to the regulations. You're flipping through or scrolling. Personal information will be publicly available for the purposes of the legislation if it is, and I'll use one of the many examples that are there, it's contained in a publication, including but not limited to magazine, book, newspaper, whether it's in printed or electronic form, and that publication is available to the public, and it's reasonable to assume that the individual themselves provided that information. Well, that sounds like social media to me. I put it on there. It's made available to the public unless I've set my privacy settings. And it's a publication, like Facebook. Book of faces in electronic form. Easy peasy. Nope. So there's a long saga with the Privacy Commissioner, and we just got a decision a couple of weeks ago from the Alberta court. And I have, you can thank me later, summarized 60 pages of case law into that chart. So this is the Clearview AI case. And in this case, Clearview AI had a great idea. It was going to provide facial recognition services to law enforcement. And this is that whole like CSI thing. The police come up, they've got a picture of a suspect, but they don't know who the suspect is. Clearview AI said, well, we've got this database of faces, give us that, we'll run it, we'll tell you who the person is. Marvelous, it's magic. For Clearview AI to do that, it had to build that database of faces. And so it did what we were just talking about, data scraping. It created a bot, ran around the internet, and hoovered up all the pictures it could find on social media, on LinkedIn. You're probably in that database. And then it built this thing. And the nice thing about that is that there's names associated with social media images, and there's with LinkedIn, you've got that. So you've got an identifiable database. It's really handy if you're in law enforcement or inclined to do this as a hobby. So Privacy Commissioner got a little excited about this. There were media reports. And Privacy Commissioners, all of them, but we're going to focus on the Alberta one, said, yeah, you can't do that, you need consent. And Clearview rightly said, no, I don't. Look, we've just talked about this exception. We don't have to, it's publicly available. Privacy Commissioner said, okay, thanks, but no, the internet's different. That's not what this means. Clearview said, okay, fine, we don't agree, but surely if someone is putting this stuff on the internet, then they're impliedly consenting to it being used. Privacy Commissioner went, no, that's not reasonable. Just because someone put something up on Instagram doesn't mean they wanted it used or were okay with it being used for facial recognition. Clearview said, fine, you guys are just wrong. See you in court. And here we arrived at the Alberta court. And the Alberta court did something differently because it looked at that publicly available exception. And it said, okay, we're going to side with the Privacy Commissioner on this one. Privacy Commissioner's interpretation that this thing is really broad is right. However, because it's interpreting it so broadly, the whole section is unconstitutional. It violates freedom of expression, particularly in this case, Clearview AI's freedom of expression. So we're going to strike it down. Basically, we're going to take out all those blue words. So now the regulation reads, personal information is contained in a publication if the publication is available to the public and it's reasonable to assume that the individual posted it. That's really broad. Now, Clearview ultimately ended up losing on this one because the court then said, yeah, well, the use is still pretty unreasonable, so Privacy Commissioner's order still stands. Poor you. So now what's happening? What does this all mean? Can you just like run around Canada, do data scraping? No, don't jump the gun on that quite yet. This is a lower court decision. It is in Alberta, and it is in one specific context. So we'll see where this case goes. But this highlights if you're doing data scraping, the law is currently in flux. So you may not actually know whether the information you have or had, depending upon where the law goes, can actually be validly used. So you're going to have to pay attention to this very, very closely. And there are folks that train AI on data scraped or information that has been scraped that may imperil the validity of the training or the databases that were used. And these are all these evolving concepts. So if you are buying AI, it's important to ask how the information was collected that was used to train the AI. If you're developing it, maybe don't just go running around the internet grabbing things. Another gotcha is inferences. I love this one. This one's fun. So the other takeaway here is you can't just create new information. So you can't use information you've got lying around. You can't use information you found on the internet. And now you can't just make new information up. So an inference in the AI context is where you've trained an AI model to make certain predictions or generate new information based on previously unseen data. So let's make that concrete. So we have a trained AI model that will predict if a user is likely to click on an ad. So the model has learned to associate certain demographic factors of a user with the likelihood they're going to click on certain content. So the inference piece comes in where the AI is shown a completely new profile. It's never seen it before. It looks at that, assesses the likelihood based on what it's learned, whether a user is going to click. Let's take that down to even a more concrete level. So I've got this trained model. I'm going to show it some demographic data. We'll say it's the model of this particular individual, this user profile, is that they're a female. They're between the ages of 35 and 45. They, at least once a month, buy kitty litter and cat toys. At least once a week, they buy a set of single-serve microwave dinners. And their viewing history on Netflix shows that they really love Hallmark movies. The ad that gets shown to them is for a singles dating site. The AI has learned to associate a high probability of clicking with the inference that that person, that user, is single. So all along, that transaction history, the viewing history, and the demographic information is personal information. But the addition now, the inference this person is single, is created information. It's an inference. It's a whole new collection. And back to that whole thing, you can't collect information without consent or without an exception to consent. In some cases, you may be able to use implied consent, and where it's sensitive information, you're going to have to get express consent. So this is an example of where you can be inadvertently, if you're using AI, you could be inadvertently collecting all this kind of information and have no idea that you're actually doing it. Now, the law here is also in flux. In the EU, there's some pretty clear statements that inferences are a new collection. Privacy Commissioner in Canada, at the federal level, it's a little squishier. We have some non-binding guidance, and it's in the context of generative AI. But assume that the law is heading in the direction that inferences are an independent collection and will require consent.
Okay, moving on to our next tricky topic, anonymization. So woven into all of our privacy laws are data minimization obligations. And these require organizations or institutions to dispose of personal information once it's no longer required for the purposes that were originally identified for its collection and use and disclosure. These obligations are intended to mitigate the harms or the potential impacts that can occur when if a data breach occurs. And they also minimize the temptation for organizations to repurpose their data sets for unlawful purposes, i.e. for like new uses for which they don't have adequate consent. Now, data minimization typically takes place by deletion and secure destruction. However, you'll recall that our privacy laws only apply to personal information. So if personal information is modified such that it can no longer directly or indirectly identify a person, then the resulting information is no longer personal information that is caught by our privacy laws. This is where anonymization enters the chat. So it is expressly contemplated in some of our legislation as an alternative to destruction at that end of the information life cycle. Tying this back to the AI context. So as I mentioned earlier, if you're an organization, you'd like to implement AI, but you're not sure whether you've got adequate consents or if the resulting processing would ultimately be compliant with our privacy laws, your first option is just not to proceed. Another option is to first anonymize any of your personal information and feed the resulting information into your AI model, because any subsequent processing by AI would be removed from the scope of our privacy laws. Now, unfortunately, until recently, our laws have done a pretty poor job at clarifying what exactly is required in order to anonymize information. And that's had the result of exposing organizations to risk. Whenever they seek to do so, they seek to rely on this anonymization alternative to destruction, and they may or may not have done so appropriately, and they may or may not still be processing personal information in a way that they think is outside the scope of our privacy laws, but is actually still captured. Quebec, again, Quebec, being our most modern province in terms of privacy laws, has changed the tides here a little bit because it recently adopted anonymization regulations, which established the requirements that organizations need to satisfy in order to have appropriately anonymized information to be able to use it for purposes that are outside the scope of the privacy laws. So those regulations impose quite a high bar. Just a few of the requirements are first identifying, I think it's serious and legitimate purposes for which any anonymization will subsequently be used. You also need to involve a person qualified in the field to oversee the anonymization process, so query exactly what those qualifications might look like. And then there are various stages of analysis and reanalysis to identify and evaluate re-identification risks that may occur following anonymization. Although this high bar is only set under our Quebec law and is not yet seen throughout the rest of Canada, if you're an organization operating here, we can really consider this to be our gold standard for what anonymization processes look like. So even if you may not be caught by that law, you can look to it for guidance in terms of what you should be doing when you want to anonymize information. Oh no, oh no, oh no, this is right, okay. I was like, where's the back button? Okay. When discussing anonymization, it's important to distinguish it from a similar but distinct concept, and that is the concept of de-identification. So you'll recall that anonymization is when the information can no longer be used to directly or indirectly identify a person. And only once that has been achieved is that information carved out from our privacy laws. De-identified information, on the other hand, is where personal information has been modified such that it can no longer directly identify someone. But given the fact that identification, indirect identification can still occur, de-identified information is typically still subject to our privacy laws. Unfortunately, again, further confusion has been caused by the fact that our laws across different jurisdictions have used inconsistent terms. And I've highlighted here on this slide just to sort of illustrate that. If we look at how the Quebec Act respecting the protection of personal information in the private sector defines anonymization, and we contrast that with how Ontario's Personal Health Information Protection Act talks about de-identification, you'll notice that they're functionally equivalent. So that's not doing anybody any favors. We're supposed to be talking about two distinct terms, and yet here, the statutory language is essentially the same. The information can't be used either alone or together to identify somebody. So this lack of clarity about what exactly is required to identify or to anonymize information and conflating terms of de-identification and anonymization, it does expose organizations to some level of risk when you're relying on anonymization to subsequently process information that is hopefully outside the scope of our privacy laws. And this is because if you get it wrong, any subsequent use or disclosure of that resulting information would still be subject to our laws, and you just may not be compliant because you don't think that it is. So we recommend caution. Whenever you see the word anonymize, anonymization, any sort of guarantee around that process being used in a privacy policy, terms of service, other contractual language, we really want to double check what exactly is being done here. So that means exercising your due diligence to ask about the processes that are being used to anonymize information, and then also conducting risk analyses to identify any re-identification risks at the outset and on an ongoing basis. This is an iterative process. It's not like a one-and-done process just when you're signing up with an AI vendor, especially when we're talking about AI. Like these tools are, by their very nature, intended to learn and iterate and self-tune. So the risks of re-identification emerging down the line really can't be underestimated when we're talking about the use of artificial intelligence and processing personal information with these technologies. I have one last slide here about a few additional best practices when we're discussing AI and anonymization, but just in the interest of time, I'm going to pass this back to Kirsten. So everyone have a quick read, and then Kirsten will discuss privacy impact assessments.
All right, I'll give you 5 seconds to read that. You've all done speed reading. This is available in the materials, so don't panic. But keying off of this, so now that we've explained all these gotchas and Jaime's shown you very large numbers and scary fines, what can you do? One of the best ways to manage these things is with a privacy impact assessment. So in terms of your return on investment, this is the one that is least cost and highest return in mitigating risk. They are not required in Canada in most private sector legislation. They are required in Quebec, and they are required in certain public sector and health sector laws. One of the best things you can do for yourself and your organization is to start implementing them. And not just implement any privacy impact assessment, implement one that is suitable for AI and asks hard questions. So the basic steps of a PIA. So PIA is basically a structured process. It asks very detailed questions, gets the answers, and then you mitigate. You identify where the gaps are, and then you mitigate the risks. So the steps are basically that you plan the PIA. You figure out who's going to be responsible and what the scope of the project is. In an AI one, it's usually you've got multiple stakeholders from across the organization. So it's a little more complicated than in many types of PIAs. If you're a public sector organization or you're doing something really wacky, you may want to do stakeholder consultation and just sort of get some feedback. If you unleash your product idea on people and they all go, oh, gods, no, then you may want to rethink your approach. And then the orange ones are the ones I'm just going to focus on quickly. Again, this is all in the materials, but map the information flows. Who's doing what? How are you getting it? Where is it going? How are you sharing it? Then you identify the privacy impacts. So you look at where there's a gap between what you're doing and what those impacts and what the laws and requirements are. You identify those privacy risks, take mitigation steps, and then you get to do it all again, particularly with AI. It is an iterative process. So that mapping information flows, what does that involve? It involves a lot of things. You're asking a lot of questions. People in the organization will love you when you're like on their doorstep the 15th time. So as I mentioned, who's collecting it? How are you collecting it? What are you using it for? Is it going to be used or processed? Is it going to be transferred? Is it going to be disclosed, stored? How are you going to keep it secure? How, in an AI context, how are you guaranteeing the integrity of the data and the quality of that data set? Are you going to do data matching? Better be careful there. So ask these questions. So let's say you've done, and the other one that always gets forgotten is your data subject access rights. If you're using people's personal information, they have a right to ask you about it, and in Quebec, there's a data portability right. You have to build all of that into the machine. So now you've got this giant map. If you've actually done it as a diagram, it looks like a spaghetti diagram. If you've done it as a spreadsheet, you've probably got something with 87 different tabs. Now you have to take everything that you've done and assess it against your privacy obligations. So you're going to look at privacy laws. You're also going to look at specific codes or sector-specific guidance, international norms, treasury directives, OSFI has some helpful things. And you're also going to look at sector-specific legislation, and the ones that come to mind is Bank Act, Insurance Act, and other sorts of things. So now you've done all of that, you might want to ask a few other questions. So even if you're compliant with the laws, you might want to say, well, maybe this information we're gathering now and using, and now that we've got this giant pile of it, now we're going to be a target for hackers. So what does that mean? How are we going to handle privacy breaches? We weren't really doing a lot with information before, but now we are. Do we know how to figure out, how are we going to handle complaints? What if there's a community backlash? So those are sort of the non-legal things. And now you have to identify those privacy risks. And there's a whole constellation of mitigation steps you can take. And I can tell you number one there, just decide not to collect certain types of data, probably not going to fly. No one ever likes it when I suggest that. There's lots of other things you could do. Maybe you solve the problem by reducing your retention time. In that applicant data example I gave, maybe you're not keeping them for 10 months, maybe you're keeping them for 2 weeks. Are you going to anonymize or pseudonymize? Are you going to, maybe you have to review your contract and really up some of the language there. So there's lots of ways to mitigate. This is an example, a sample PIA question, just to give you an idea of the format. So on the one hand, the side you see there, principle. So this is mapped to a principle of consent. And then there's some possible questions you can use. Now, this is a truncated version. I think I have, my list has something like 50 some odd questions you can ask around consent. And then there's considerations and impacts. And you can address, those are the things you address once you get your responses back. And again, this is in the handout. I think there's a couple of these sample PIA questions. So this is what a comprehensive PIA for AI looks like. And again, wall of text, don't worry about reading it. It will all be there. Great bedtime reading, let me tell you. So we also gave a survey. And not surprisingly, you will see that the vast majority of people who responded find the number one pitfall here is in that lack of clarity around the controller and the processor distinction. And that's exactly what we see in our practice. 23% is other, not particularly helpful. So maybe we'll drill down on that next time. The other big one, anonymization and de-identification. You're talking at cross purposes. And then there's a few dribs and drabs all over. So we hope you benefited from that. Now is the question time, so please feel free, throw a question at us. We love a challenge.
We have approximately 2 minutes. Any questions?
All right.
Okay, so what legal and privacy risks do companies face when using de-identified data for a look-alike digital marketing campaign that leverages AI? So given that some privacy policies claim that de-identified data is not considered personal information, right? Is this interpretation accurate under privacy laws? And how could companies mitigate the risk if they are engaging in this type of digital marketing campaign?
In a minute or less?
Yeah.
Okay. All right. Which privacy law, first of all? And de-identified information is still within the regulatory perimeter. It is still subject to privacy laws in Canada. It might reduce the sensitivity of that information, but it is not a get-out-of-jail-free card. So if you are using de-identified information for which someone can track back, I can combine 2 data sets, you're still within that regulatory perimeter and you still have to treat it as personal information. So that's all I can answer in 1 minute.
Okay, and Kirsten, another question. So if you are a startup company or even just a fast-moving company, and you, as has happened in the history of commerce, so you want to get a product out there quickly and just see if there's a revenue opportunity there and if there's any market traction. I mean, is this just, maybe it was always a dumb thing to do from a legal standpoint, but is it just truly something that you can't do anymore? Like, what is a model where you can iterate quickly, right? See whether or not there's a potential for that product, solution, or tool, right? And if there is, then go back, deal with IP, regulatory compliance, privacy, et cetera.
Yeah, and that's a pretty typical approach for fast-moving companies, is the legal comes last.
Right.
So do a risk-based analysis. My advice, probably don't launch in Quebec. There's big penalties, big numbers there. Choose where you're going to go in Canada. Don't do a big announcement to the world that you're launching this really cool, scary thing that's going to attract the attention of the privacy commissioner because the media is going to cover it. So do a small scoped pilot, seed, proof of concept. Do that first and then build in the privacy protections as you go, again, on a risk-based basis. There's some things that are going to be far scarier than other things. So a good example is doesn't cost a lot to put out a privacy policy, but I guarantee you, if you don't have a privacy policy, somebody's going to go, I don't see a privacy policy, and then you're down that road.
Okay, great. Okay, Kirsten and Jaime, thank you very much.
Thank you.